please announce the agreement.
Yes, Your Honor. Ms. Donson is pleading no contest to count 1, and it is count 3, so the fleeing or attempting to elude and driving while license suspended. Ms. Donson will complete 3 years probation. She will be eligible for early termination at the statutorily allowed halfway point, so the 18 months, if she completes the terms of the agreement. $515 in court costs, $150 public defender fee, 24 hours community service, and a 365-day driver's license suspension. And there are a couple of other things there, the random urinalysis, and no drugs that are not prescribed, and no firearms during supervision. And maintain gainful employment during the time of supervision as well.
State.
Yes.
Ms. Donson, would you raise your right hand, please? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God.
Yes.
So you heard your attorney state the terms of the plea agreement,
Yeah.
and I see those terms are in the written plea agreement that you have signed. Have you read this closely?
Yes.
Have you gone over it in detail with your attorney? Make sure you understand you got all your legal questions answered? Yes?
Yes.
This section is being recorded. Okay. So, and you understand that by entering into this plea agreement, you're waiving the right to go to a trial, some other valuable constitutional rights. Do you understand that?
Yes.
Believe it's in your best interest to do so.
Yes.
Based upon that testimony, the court accepts your plea. It's a very small detail. Right. The way you word it, you should leave that as a 3. Just right there, just put it in that. Okay, no, just very small detail. So, and the state is null processing counts 2 and 4.
Yes, sir.
So, as to the remaining counts, counts 1 and 3, the court will sentence you to 3 years. You're challenging my ability to read.
Sorry.
So,
It's 36.
no, hold on.
Oh, I'm sorry.
On count 3, the driving unsuspended, what is the sentence?
Well, I suppose it would be 1129 probation concurrent with the 36 months probation on count 1. If you'd like me to specify that, I can edit that in the.
Well, in your maximum incarceration, it says the maximum incarceration is 60 days.
Oh, it's the second degree. I apologize. So 6 months probation.
I can add the 6 months probation.
So you need to put the sentence for each of the charges. Okay? So as to count 1, the fleeing and attempting to elude, you're being sentenced to 3 years of probation, and you may have early termination of probation at the halfway mark, 18 months. assuming there's been no violations, which is always included, you need to put it in writing here. So it's an early termination if no violation. And as to count 3, you're sentenced to 6 months probation is to count 2. That's count 3. But that's concurrent. So it's basically a total of 3 years, although it's really 6 months and 3 years, but they're running together. Okay, you understand that?
Yes.
It's technical, but it's important. And you've got standard fees and costs, community service hours, 365-day driver's license suspension. You must maintain gainful employment, and no non-prescribed drugs, no firearms for any meals. Okay, any questions?
The adjudication.
Okay. I'm sorry?
The adjudication.
This is an adjudication of guilt on both charges. Thank you.
Ma'am.
Next. Anybody else?
Yes, Your Honor, I have Dustin Ford.
Yeah, you can send
He's approaching. This is docket 2023 CF 2141. Your Honor, the state and the defense have reached an agreement in this case as well. If I can approach.
Please. Thank you. Would you please announce the case, announce the agreement, please?
Yes, Your Honor. This is an adjudication of guilt on both charges as charged. In count 1, 36 months probation, waive the cost of supervision. In count 2, it would be credit for time served, $615 in court costs, $150 public defender fee, substance abuse evaluation within 30 days and any recommended treatment within 60 days, random UAs, and Mr. Ford is entering the plea without the opportunity to review any FDLE reports, as we did not receive them in discovery as of yet. And this will be a adjudication of guilt.
You're not going to say anything about a recommendation?
Oh, I'm sorry, I can't write that part in. And then Mr. Ford will be eligible for early termination if there are no violations at the halfway mark, 18 months.
Very good. Mr. Ford, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth so help you God?
Yes, sir.
Is this stated in the agreement? You can put your hand up.
That's correct, Judge, and he does not score. We can get you a copy of the score sheet.
I have.
Perfect.
So, Mr. Ford, you heard your attorney state the terms of your plea agreement. As she was saying, and I was following it. It's contained in your plea and sentencing agreement that you have signed. Did you read this closely?
Yes, sir.
Go over it in detail with your attorney, make sure you have all your legal questions answered.
Yes, sir.
And understand by entering this, you're waiving the right to go to a trial, and in order to be able to have a final resolution of this case here today. Is that what you want to do? You believe that's in your best interest?
Yes, sir.
And you have had all your legal questions answered?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on both counts. As to count 1, the defendant will be sentenced to 36 months probation. You will get the benefit of the waiver of supervision during the term of probation. In count 2, you'll get credit for time served. There are the standard court costs. You must have a substance abuse evaluation within 30 days and follow any treatment within 60. You'll be subject to random UAs. And also, you are eligible for early termination at the halfway point, which is 18 months. You haven't violated that. Okay? Any questions?
No, sir.
You do have 30 days to appeal. Mr. Donson.
Did you say waiving supervision or waiving cost of supervision?
Waive cost of supervision.
Thank you.
I did say waive supervision. That's what happens when you do 20 or 30 of these in a day. You lose track of it. Catch me on those, because that's what you get it right. Council, we got another one?
I have two more. I have a waiver that I'm going to file for Dustin Choquette, Choquette,
Okay.
docket 2023 CF 1795. This was put on for today in the hopes and the plan that Mr. Choquette would accept an offer. The state and I have been in contact about it, and we'd like one more continuance. There's a couple things we need to iron out still.
Full cycle.
That's fine. Yes, that's fine with us.
4A. Continue to 4A.
And then the last one, Your Honor, is Cody Frazier, Frazier, 2023 CF 1945.
Okay.
This was put on today for the same reason, but Mr. Frazier needs a little more time to think about the offer. If we could have one cycle of continuance.
Very good. We'll continue this to 4A.
Thank you, Your Honor.
Steve.
Is that all you got? Out of
Yes.
custody?
Yes,
Okay.
thank you.
Gates, anybody, anybody else out of custody? Okay. Who wants to, which of the public defenders wants to go? Ms. Farkas?
Ready.
It'll make it easy for court security to run the list.
Sure.
Yep.
This is my last night, Steve.
I only have
What
two.
about Mr. Harper? Mr. Harper hasn't had all of this. I'm good, Judge. You want?
Well, he's loading this Marcus.
I only have
Farkas
two.
loading
I
right
got
now?
three.
Okay. Let's do Ms. Farkas and then we'll do Mr. Harper.
Chenault, Coker, and Deathridge.
Chenault is still Steve's client. You kept Mr. Chenault?
Yes, ma'am.
Yes.
Okay.
Yep, that one is
But we can
incorrect.
get him out if he's in the queue. They'll just-
Yeah.
Well, that's, we've got him loaded up because it was listed on ours as
I can take
Ms.
it.
Farkas.
It'll just be about a minute.
I'll get her
Yes,
two
listed
and
as
then.
Farkas, as Farkas.
Yes, Your Honor,
Okay.
I kept Chenault, and we just didn't get it updated yet.
Mr. Coker.
Counsel, we do now.
Your Honor, this is Christopher Coker, docket 2021 CF 1428. The state and the
I'm
defense,
sorry, could you say?
sure, sorry, Coker, Coker. 2021 CF 1428.
I thought we were doing Chanel.
Well, I
Chenault's
was getting her
next,
two.
Your Honor.
I got her two loaded and I was going to finish his.
Oh, okay. Coker. Very good, Ms. Stark, go ahead.
That's okay. Thank you, Your Honor. As I was saying, the state and the defense have reached an agreement. In this case, if I could.
Amen.
Yep.
Thank you. Could you announce the plea?
Yes, Your Honor. This will be an adjudication of guilt on all counts. Credit for time served, $967 in court costs, and a $150 public defender fee.
You're under that as state's agreement.
Counsel approach.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
On both counts, you will get credit for time served. That's essentially your sentence. It's credit for time served. And you got court costs and public defender fee. I'm going to give the defendant 180 days to pay it.
Yes, Your Honor, thank you.
You have 180 days to pay the fees. That'll allow you to pay them, so then if not, you go and get it.
That's not right.
You go up against your driver's license. So you got to pay within those 6 months or they'll take your driver's license. Okay, you have any other questions?
No.
Okay. You do have 30 days to appeal this. Good luck.
This way, sir.
Next.
Lisa, can you get this way? Can you get Deathridge?
Deathridge.
You announce?
Yes, Your Honor. This is Naran Deathridge, 2 dockets before you, 2022 CF 0959 and 2023 CF 2154. The state and the defense have reached an agreement in these cases. If I could, I just want to make sure because I only have 1 copy.
If you only got 1 copy, then you should reach out.
Okay, I'll go simply, Your Honor. In docket 2022 0959, Mr. Deathridge will admit the BOP, which will revoke and terminate the supervision. In 2023 CF 2154 would be an adjudication of guilt, $615 in court costs, $150 public defender fee, 12-1 DOC, and credit for all time served on all counts in all cases.
Your Honor, that is the case.
Thank you, Your Honor. And I previously went over this offer with Mr. Deathridge.
Okay.
If I can approach.
So Deathridge, would you raise your right hand and swear or affirm the information you're about to provide to the court is the truth, nothing but the truth, so help you God? Yes, sir. your attorney state the terms of your plea agreement. I see those terms are contained in the written plea agreement. Did you read the written agreement closely? Did you go over it with your attorney in detail? Make sure you have all your legal questions answered about the plea agreement. You understand by entering this plea agreement, you're waiving some valuable legal rights, right to go to a trial, right to contest witnesses. These are all constitutional rights you have. Believe it's in your best interest to enter into this plea?
Yes, sir.
This will be a final resolution of this case. Is that what you want?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be an admission to the VOP and no contest to the new law charge. As to the VOP charge, which is 22-959, with the admission of the VOP, the court will revoke and terminate supervision on that count. In 23-2154, will be an adjudication of guilt. Some standard fees and costs are contained. The defendant will be sentenced to 12 months, 1 day in the Department of Corrections. You will get credit for all time served on all counts and in all cases. Okay. Any questions?
No, sir.
Thank you, sir.
Thank you. Your Honor,
This way, sir.
monetary obligations and...
I'm sorry.
Monetary
Next to Mr.
obligations
Chenault.
will be please.
Given 6 months to pay. Mr. Deathridge. Mr. Deathridge. When you get out from the DOC, you'll have 6 months to pay the cost and fees. So then go out there and go against your driver's license, okay?
Okay. Thank you, sir.
You got to pay it before then. Thank you.
Thank you.
Your Honor, Steve Medina with Craig Chenault, Chenault, and Assistant Public Defender Medina is keeping Mr. Chenault's case, and we'll update that with the clerk's office.
Okay.
23 CF 1687. Your Honor, this morning I provided Ms. Basso some written information pursuant to a stipulation that had been reached with her, and we're asking to continue this pretrial to April to see if we can resolve the case at that time.
That's without objection, you did that, provide that.
You want to continue it until,
Would that be April or March?
We can get March. I mean, I'll have to.
You know, I realize now that I keep putting a lot of things on March 14th when I will be out of state, and I'll never continue to April.
We can always get notice, we need to get a resolution if there's a spot on the docket.
we'll continue this till 4:10.
Thank you, Your Honor.
RCC's going to come.
Let's just take one moment for them to get them loaded in, and I'm having your mails come out first. First should be planned.
Mr. Medina, if you'll remind me, we do have a miscellaneous on the 19th when you're coming back. So if somebody says, the 14th, you just
Thank you, Your Honor. I'll check
kind of
through that.
remind us and we'll put it on.
Yes, and if it's something, I don't want to say real simple, but basically if it's something that I can, in good faith, pass on to a colleague, we'll just keep it on the 14th.
There's no way to say it otherwise. Just that.
Judge, this is June 9th, 1949 on the docket. Here's the court reports on 23 CF 2522. This time he's going to withdraw his previously entered plea to no contest. This will be a plea to a lesser included offense of misdemeanor trespass. be adjudicated guilty, placed on 11 months and 29 days of probation, $270 in court costs, $150 cost of defense. The probation will be with JCS. No trespassing at 215 Waldorf Lane, Mary Esther. No contact with Marvin Inmates. No drugs not prescribed, and no firearms in the church. This is a misdemeanor, so there's no scorching.
State.
That is the state's position.
Mr. Klein, would you raise your right hand, sir, and swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Do you heard your attorney state the terms of your plea agreement? I see those are contained in the written plea agreement that you signed. Have you read it closely and gone over it in detail with your attorney?
Yes, Your Honor.
You understand that by entering this, you're waiving the right to go to trial to the final adjudication of this case?
Yes, sir.
Believe this is in your best interest to enter into this?
I do.
You have had all your legal questions answered?
Yes, sir.
Based upon that, the court will accept your plea to a lesser included offense of misdemeanor, trespass. There'll be an adjudication of guilt on this lesser included offense. You'll be sentenced to 11 months, 29 days of probation. You've got the standard court costs and fees. And the probation will be with JCS. And there's a couple other conditions, no trespass at the Waldorf Lane in Mary Esther, no contact with the victim on that, no drugs, not prescribed, no firearms. Any questions?
No, sir. No, Your Honor.
Good luck.
Next is Ms. Antonio Clark.
Antonio Clark. Judge, you before the court on 23 CF 2020, 23 CF 2098. Judge, he is set for tomorrow for bond hearing. So I'm just bring back to you the result of this with the bond hearing.
Do we already have that set?
Your Honor, I was looking at the docket for tomorrow. I will use our,
Yes, Your Honor.
Costin.
Judge, this is Michael Costa, 23 CF 1401, 23 CF 1402. Judge, this is Mr. Costa before the court. This is an open plea to the court, capped at 12.1 months, Department of Corrections. You don't have to score sheet at this time. He does not score 12.1, or he does not score period. But we would like to proceed for the sentencing.
Are we going to order a yes, no, sir. Okay, Mr. Costin, you please raise your right hand. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea.
Yes, sir.
I see you signed the plea agreement. Have you gone over this with your attorney and understand kind of the risks and the benefits of doing a plea to the bench?
Yes, sir.
Because as I look at this, you've got 4 separate charges, and a total of 16 years. That's max. And I'm not saying you're getting that, but that's out there. You understand that?
Yes, sir.
Well, that's actually not true, because you're capped at 12 points. So it's not 16. So, you're attorney jump out?
I was waiting for you to stop.
You're waiting for me to stop. So, even though you have those as the maximums, you have a cap on this, you will have the opportunity to argue. Not you and your attorney. And the state will argue, and I'm sure the state will argue for the cap, and I'm sure you're arguing otherwise. Now, let me ask you a question. Does this agreement limit any supervision probation? It says cap to 12.1, and it kind of leaves it vague about whether there's a cap on probation or what.
Was my intention to limit supervision to 14?
It was or was not?
Was not.
Notwithstanding that, Judge, I don't think our respective positions anticipate some sort of split sentence. I think we're anticipating a flat jail or either 12-1 PSC. We're not asking for supervision, but to answer the court's question, there is no cap.
Okay. So the court could order supervision, could order probation instead of DFC thing, right?
Yes.
Okay, so feel like you understand what's going on? You feel this is in your best interest to enter into this plea agreement?
Yes, sir.
Okay, are you ordering a PSI on this one?
No, Judge.
Okay.
We're hoping for, if the court will permit, a fairly short turnaround, and that this, from a factual perspective, is not that complicated. I don't think we even have to need docket or anything of that nature. If the court has a next available date that's not too busy, for lack of a better word, I think the sentencing could be fairly quick. I don't think our respective arguments will take more than about 5 minutes.
I mean, as soon as we'll be able to do it is in March. No, we can't do that on jury review, and that's the last one before we go into our trials. The following couple of weeks.
If we could set it for the next bill earliest, and I know that typically you ask us at this thing afternoon, but that I don't anticipate it'll be lengthy or prolonged. I certainly don't anticipate.
We'll put it on the first miscellaneous docket that we've got. Unfortunately, our miscellaneous dockets are all. We don't have any more. Well, we've got them tomorrow. Is that too soon?
It's not too soon.
What do we have tomorrow? I don't know. I got it tomorrow. Definitely won't go to the 22nd.
So in the morning we have 44, we have Wayne, there's 20, and 2, 4 minutes.
Is the state ready to go tomorrow?
Your Honor, I could try, I just need to reach out to the victim in the 1401 case one more time and see if she wants to be here. I anticipate that she won't, but I just need to reach out.
Let's set it for tomorrow. For some reason, you haven't met the requirements under, certain requirements under the victim's rights to call Marcy law, you might have heard. And if the state can't comply, it may be a reason to push it. We'll try and do it tomorrow. We'll be in the morning.
Next is Edwards.
Judge, next is Eric Edwards. He's before the court on
Edwards.
21 CF 1210, 21 CF 2883.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Judge, this is Mr. Edwards before the court on 21 CF 1210, 21 CF 2883. He'll be entering a plea as charged, 21 CF 1210-1. This will be a plea to 6 counts of lesser included offense of amphetamine trafficking greater than 14 grams or less than 28 grams for counts 1, 2, 3, 4, 5, and 6 in 21 CF 2883. Be adjudicated guilty. Serve 3 years Department of Corrections, minimum mandatory, concurrent on all counts and charges, credit for all time served. That will be followed by 3 years of drug offender probation, curfew of 7 p.m. to 7 a.m., which may be adjusted for employment purposes, concurrent on all counts and charges. That will be followed by 2 years probation, all applicable court costs, and the mandatory fine, and all the probation is upon concurrence. You may approach, Judge.
1210, did I not hear you on that?
1210.
You did 6 counts on 2883.
Yes, sir. He's pleading as charged to 1210.
Okay.
And
I just didn't hear I didn't hear a sentence on that. Maybe I.
Oh, I apologize if I made that a little bit confusing, Judge. It's the intent to have this, all of these counts and charges run concurrent with one another, and the sentence will remain the same.
Okay, very good.
You may approach.
No. I'm going to ask you some questions in open court.
Okay.
And then we'll.
Yes, sir.
Okay. So, Mr. Edwards, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you've essentially got seven charges. That's 1 and 1, 6 and 1. And you're pleading no contest. There'll be adjudication of guilt of each of the 7 charges. And there are lesser included charges from the ones you were originally slightly lower on each one. So it'll be the lesser included offense of amphetamine trafficking over 14 grams, but less than 20. So those are for each of the 6 count in 21 CF 2883. And also the same is plea as charged is not a lesser on the 21 CF 1210.
No, sir, as charged.
So as charged for that. Okay. And what's the sentence on that one?
It is also 3 years, Department of Corrections, minimum mandatory, followed by 3 years, government probation, followed by 2 years of supervision.
Okay, so all 7, when it says all counts and charges, all 7 for the 6, and then the additional. Okay.
Yes, sir.
That was what was confusing. I'm sorry. So, with those lesser included, there'll be an adjudication of guilt. You'll be sentenced to 3 years Department of Corrections, minimum mandatory, concurrent on all counts and all charges, credit for time served, followed by 3 years drug offender probation. There's some curfew, and it may be adjusted for employment purposes, concurrent on all counts and charges, followed by 2 years probation. All up will court cost $50,000 fine. So you've got, so that's a total of 5 years probation?
Yes.
3 plus 2.
Yes, sir.
Okay. So you got the 3 years DOC, 3 plus 2, 5 years probation.
Yes, sir.
Okay. Would you approach it? Okay, so based upon all the understanding of this plea agreement, you feel comfortable this is in your best interest to enter into this plea agreement?
Yes, sir.
And you've talked with your attorney and had all your legal questions answered?
Yes, sir.
Okay. Even though you just entered into this plea agreement, the court does have to tell you you have 30 days to appeal, even though you just entered into it. It's a little weird how they do that. And the score sheet, you all are integrated?
Yes, sir.
Okay. Very good. Any questions, sir?
Yes, sir.
Okay, thank you.
This one. Next is Golden.
Next judge is on 7 on docket, Craig Golden. He's before the court on 22 CF 256, 22 CF 288, and 22 CF 2095. Judge, after speaking with Mr. Golden, I brought this up to the state. One of the issues here is that Mr. Golden is correct. I think that there is arguably a potential motion to suppress with respect to the case that the state would like to proceed forward to trial 22 CF 288. The issue being that I filed a motion to suppress in someone else's case that was materially similar to the facts as was here. And the basis of that was that whether or not the odor of marijuana was in and of itself sufficient probable cause for the vehicle. It was a holding vote this court in the First Judicial Circuit. There was a case law with respect to that that denied our arguments. However, arguably there's a circuit split in the Judicial Circuit has argued something different. Notwithstanding that, it had not been my intent to file a motion to suppress because of the fact that I was aware of the ruling both by this court as well as by the First Judicial Circuit. However, Mr. Goldman raised a legitimate point in that if that motion is not filed and is not heard, arguably he can't appeal it later. And that's his contention. With fairness, Judge, I think this is a legitimate argument. If in case everything goes sideways, if that motion is not filed, the hearing is not held on it, notwithstanding what I anticipate the results will be, he cannot subsequently appeal it if I didn't file it. So in light of that, Judge, I think it would be prudent to ask for one more continuance on this matter, file the motion. I can get that filed hopefully before jury review on Thursday, because it's not dissimilar to the last one that I filed. And then we can proceed forward. My understanding is the state, of course, objects to this, because this is on docket day, but that is the position of the defense at this moment.
The state strongly objects. Judge, I know that this court is well aware of the case law on point with that issue. We've argued motions in front of you previously that are identical to, or I would say nearly identical to this case. I've spoken with Mr. Harper and let him know that my wish is for us to not be taken off the trial docket. I think that there will be, if he could file his motion by Thursday, we could get it set to be heard before this case goes to trial. I know the court doesn't want to talk about scheduling, but I do believe that there's going to be time next week that his motion could be heard and we can proceed on this on the second week.
You already phoned my calendar next week? I mean, if you know you have it cleared.
Well, Judge, I spoke with my cohorts and about the time. I don't want to get too much into it, but I do believe that we're going to have some time next week. If we could come back on jury review and give Mr. Harper an opportunity to file that motion, like he said, I expect it's going to be nearly an identical motion to what was filed with the Michael Jenkins case, which is also due for trial this cycle.
So, what is your response to his argument? I mean, everybody's in agreement that these facts, that the first DCA, which, by the way, it doesn't matter what the other 6, how many do we have now? The other 5? We used to have 5 total, now we have 6. The other 5 DCAs, doesn't matter what they say. If the first DCA says something, we got to follow it. Of course, the Supreme Court is the ultimate, but we're obligated, not a voluntary. We're obligated to follow the first DCA. But I don't understand. So you're saying there's a split with another circuit, and you're saying if it would be opposed, I mean, if it would be resolved at the Supreme Court level in favor of the other circuit, and he had not filed it, or you had not filed it on behalf of him, then he would lose that.
He would not preserve that particular issue for appeal. And I think that's a legitimate argument that the client brought up. In that, it's become the advent of medical marijuana as well as hemp and all that stuff. I think that at some point it will come to a head. Ultimately, I think the Supreme Court would make a determination just so that we know everyone down the line knows what to do.
So are you opposed to the time, Mr. Lasco is basically just proposing an expedited schedule. He's opposed to it just because
he's trying to move things along.
Yeah, he's trying to move things along.
And what I'll say from
and the court wants to move things around, and generally the defense wants to as well.
Yeah, these are in fact old cases. However, logistically, I have some concerns about whether or not all of this can happen within that concise period of time.
Yeah, but you understand, you're basically laying this out to preserve.
Yes.
I mean, this is not, you're acknowledging, you could make the argument, can you file something? I guess you could file somebody knowing it was a loser, but you're doing it because you're trying to preserve in case the Supreme Court overruled it, like that. If there's a general rule, you can't file something if you know you don't have a good basis for it. But in this case, I think, I don't want to say it's an exception, but it would qualify.
I think there's more than a mere possibility that this could be an issue.
Yeah.
Your Honor, you asked for my thoughts, and then it shifted back to Mr. Harper, but I would say that I have all my subpoenas out. The state is ready to go to trial, and if the court set the motion for next week, the state could, since we have our subpoenas out, I can make sure my officers are there. We're ready. And I've argued this motion before, so I can argue it again, no problem. I could argue it today, but it didn't file.
What I would like to do, Judge, if we could read Mr.
I'm a little sympathetic, Mr. Losco, because, I mean, we're at docket.
Sure. What I'd like to do is if we can bring it back on jury review, I'll get the motion filed in the interim, and then we can perhaps readdress it at that time.
Okay, let's do it.
And to clarify, Judge, you don't want to hear it on the review? Okay, thank you.
But we'll have a better idea of what all's going, more than just kind of surmising.
So this Thursday. Jackson. Judge, this is Mr. Jackson. He's before the court of 23 CF 1887. Judge, it is in our position to leave this up for trial. That was our argument on the pre-trial conference. I believe the state has a different opinion with respect to this case.
Yes, Judge. This is a very new case. We approached last time, and I informed the court that I need to be able to speak with the victim. Because I did not know that the defense was going to ask to try the cycle, I had not spoken with the victim. The court informed me to try to make contact and see if I can make it work this cycle. The state has attempted to make it work this cycle, but we have not been able to be in contact with the victim. So I'm not ready for trial this cycle, Judge. I would say that this is very early on in the case. No depositions were conducted. The state can't try this cycle, Judge. We would ask for a continuance.
I think because of the early nature of it, I have to agree. And as much as we like to move, including yourself, we like to move. I think we need to draw back on this one, contact the victim, and if there's any discovery that needs to be made, hopefully the next cycle, we'll get ready to go to trial.
Judge, what I would like to do, if the court will permit, is that one, for the record, I would object to the continuance, but two, I would ask the court to allow me to move Mr. Conderas Jackson to tomorrow for a bond hearing. We anticipated going to trial because he needs to get out and support his family. And we anticipate that we have a high probability of success at trial based on the facts. But in light of the fact that we're being asked to move this to the April pre-trial conference, I would ask if we can move this to tomorrow for a bond hearing.
Your Honor, my concern about a last-minute bond hearing is the same that I have about a last-minute trial. The state needs to be able to let the victim know. We have not been able to make contact with the victim yet. And I'm not opposed to setting for a bond hearing, but if we could set it with enough time, can you try to reach out and write it through the mail? Because I might have a bad phone number. That's what I'm concerned about, Judge.
And Judge, what we'll do, and I understand his argument, and it's materially the same with respect to the trial. I will set it for a bond hearing in March 19th in the miscellaneous date, and I'll get that hopefully filed and notice this week.
Very good. Thank you.
Thank you, Judge. And when are we setting it for? Is it 4/8?
4/10.
4/10, but I'll get notice for a bond hearing on March.
Thank you.
Jenkins?
Judge, this is number 61 on the docket, Michael Jenkins. He's before the court on 22 CF 2308, 23 CF 314. Judge, this matter, I think specifically case number 314, was left set for trial. And I argued at a pretrial conference that I need some additional time because Mr. Jenkins is requesting that I give independent analysis of the narcotics in question. court instructed me to see about what kind of timeframes I have to work with respect to obtaining a FDLE or an independent analysis and how long that will take. I have not been able to retain somebody. I've left messages and we've initiated some correspondence going back and forth, but I don't have a timetable for when that will occur and when the results will be in. I think that Mr. Jenkins' argument is legitimate. I think the way this process generally works is that we receive the FDLE results and we take them as sacrosanct, and they are what they are. However, we do know that there are times where the FDLE report is not accurate. And this might be one of those times in Mr. Jenkins' argument.
When did the FDLE report come out?
One moment, please.
Judge, I think it was August 20th. And one of the issues that we have with respect to the FDLE report after reviewing it and during the course of trying to prepare for trial is one of the results in this particular issue is that they analyze specific tablets. And even in their report, they say one tablet, one or more of the substances cannot be identified due to interfering mixture components, which is troubling because what exactly does that mean? So I think that at a minimum that an independent analysis to determine exactly what the contents and the weights of each tablet in any specific tablet would be relevant, because whether or not that particular item is a narcotic or whether or not it's a filler is pertinent to the actual weight of the substance in totality, which impacts overall the consequences and sanctions from a sentence.
Yeah. Sure. Judge, based on my records, I see that we got this lab report on January 20th, 2023, so it's been over a year that this could have been sent off to an alternative lab to be tested. I would also point out that on that lab report, it looks like there are multiple different types of tablets that were all tested, and I also see that lots of them came out as meth. I didn't print this out to show the court, but I would say that it's the state's position that the time to have this tested by a secondary expert has passed. We are at docket day. And Judge, the state is ready to go. Our subpoenas are out for trial. If they question our methods for testing it, a deposition could have been conducted of the FDLE analyst, but that wasn't done either.
And my only response to that, Judge, I think that the state might be confusing 314 for case number 22 CF 2308. In 314, the case is currently anticipated to go forward to trial. He was only arrested in February 23, so the FDLE could not have been done in January. And the report itself shows the lab report date of August 25th, 2023.
He's correct, Judge. I was looking at the wrong case.
And it's
But Judge, I would also point out that purity of meth does not matter in Florida. A mixture of different substances is enough to meet the statute. So Judge, I would continue to say that enough time has passed. A deposition could have been done to look into the methods that we use here in the state's ready for trial.
Our response to that, Judge, is that I would ask for one last continuance to get independent analysis of these narcotics, Judge.
Could you get it in one continuance? Aren't you going to have to go send it off somewhere and then have somebody apply? You're telling me you're going to get it in the next cycle?
I cannot with certainty say that it would happen within 60 days, we would have from now to the next cycle. But it would be my intention to sort of, I completely understand this position of the court as well as the state that they want to move this case forward to trial. I understand that. And but for this issue, I would proceed forward to trial. But I think that Mr. Jenkins has a legitimate point. And
So what is tell me the point?
the point is that, Judge, that DLE result itself came back one or more substances, one particular tablet that they analyzed. They came up with a specific weight and said one tablet of each logo analyzed. One or more substances cannot be identified due to interfering mixture components. And it's our position that if they don't know what is contained within the actual tablet,
What's being, if there's an unknown substance in the tablet, that's not hurting your client. He's not being charged for something that's unknown.
Sure, Judge, but it's their position that that weight cumulatively adds up to a trafficking warrant. And so that amount, it would make the difference between a trafficking charge or a sale, manufacture, delivery charge, or even a possession charge. Because
So you're saying that when they do these analyses, if you've got whatever the weight of the tablet, and, 1/100th of it is, the drug, and the rest of it's filler, that you have to determine the weight of it based on trafficking, based on
the total weight of the pills,
Yeah.
the state's position is.
Is that not true?
Well, it's,
I don't know. I mean, I just always assumed that. I've never heard this argument, honestly. That's what I'm trying to understand.
I think that for me, what's catching my attention is that sentence saying one or more substances cannot be identified due to interfering mixture components. This is a drug lab. Their entire purpose is to analyze and determine what these substances are. And if they cannot determine what the substances are, but they're using the ultimate weight and nature of something to sanction my client, I think that's problematic. And so I think it would be prudent to just have this identified by a lab that isn't by the state.
Judge, I point out that we're not a purity test state. If there's a mixture, if we look at the total weight and if the drug is present within that weight, that's my first argument. My second argument is that when I read this lab test that we did get on August 25th, 2023, numerous drugs were tested. There was 1 purple tablet and 7 yellow tablets. When the lab tested the purple tablet, and that's the tablet that Mr. Harper is referring to, the tablet itself was about 2.68 grams. But when they tested the yellow tablets were 26.71 grams. In those tablets, it does not contain that language about 1 or more substances. So obviously the larger amount, mass-wise, didn't have that extra comment. But I would say that that extra comment doesn't even matter anyway, because we're not a purity test state.
I'm generally, there's legitimate arguments for the defense. I'm generally willing to give it a delay. I'm going to deny the delay. I think we need to go forward.
Okay, we'll bring
Jury review, and I don't think there's been issues raised, and if it was raised, the court questions the timing. So, based upon when the test, what could have been done.
Yes, I understand.
So we're going to come back on jury review on the 22nd. Get ready for trial. Thank you, Judge. I believe that's all my mails. I don't know if we
Got
So
Sierra
we
back
take
next.
the 2308 and continue that until the next cycle. Is that how we?
Yes, sir. We can just track this.
Okay, let's just try.
Thanks.
Judge, this is number 44 on the docket. Sierra thanks. This fourth court on 19 CF 1454, 19 CF 1459, 21 CF 454, 22 CF 7278, and 23 CF 1170. Judge, the state and I have been in negotiations back and forth, and at this time, we're not able to come to an agreement. I think that Ms. Banks has had some recent changes and that she's been approved to some substance abuse treatment programs. I just need to speak with the state, see if we can incorporate that into a possible resolution. If we can set this for the miscellaneous date, March 13th, I think the state is possible.
I'm not following. I
If we
got
got
a clear trial on my docket for this case. Did I do that wrong?
I did not have those notes for the second time.
I mean, if I got it wrong, I don't know.
In fairness, Judge, these are obviously some old cases. I think that the newest charge, 23 CF 1170, is.
I have clear continue written on the minute sheet, Your Honor.
So what are you,
Just some history, Judge. At the very onset of negotiations, a little while back, we were trying to incorporate resolution as an alternative to DLC. We were trying to incorporate rehab as an alternative to DLC. And I think we're all on cards. Ms. Banks was not able to get accepted into any of the more traditional rehab facilities. Then we were trying a different approach. But she has subsequently just become accepted into a couple of different rehab facilities. And we're hoping to incorporate that into the ultimate resolution, Judge. It was not our intent to try this at this site, but I don't know if we're.
okay, both of y'all were saying that, it's possible I have it wrong. Clerk is the tiebreaker. Clear continue, you granted the continuance until 4/10/9.
If we can actually move that to miscellaneous 319, Judge, if possible. I'll get the rehabs that she's been approved for and see if the state is amenable to doing something other than DLC.
Okay, very good.
Chief. Next is Ms. G. This is Kathleen G, Judge. She is number 56 on the docket before the court on 23 CF 1674, 23 CF 2204, and 23 CF 2565. Judge, she is set for a bond hearing tomorrow morning. We can just bring her back. It's set and scheduled. I think she's on the
Okay. Tomorrow morning?
Thank you, Judge. I think that's all I have today.
That's it.
Your Honor, yes, sir. While we wait, Mr. Harper and I were wondering if you want to first draft some of these jury instructions.
Generally speaking, we're looking at what jury reviews the whole law. But, because we don't know who's committing, it could be the very following week, so we're kind of, if I knew exactly when we were going, I could say, well, we come back, we usually want them a week before.
Okay.
But we we don't know exactly when we're trying to still figure out. I mean, when I leave today, I'll be going back and looking at, what are our real trials here? Trying to figure out a little bit. And I know you all are, sometimes have suggestions about what the problem is. Thank you.
Your Honor, Steve Medina with Carly, Alderman Ford. And she's before the court in 23 CF 2176, 22 CF 2927, and 22 CF 2665.
Okay.
May the state and I please approach, Your Honor?
Sure.
Your Honor, I would ask to have Ms. Alderman Ford return on jury review. It's for a plea or continue.
Very good. 222 at 90.
Thank you, Your Honor. Okay.
You want to start with the max? You want to start with the max?
I can do that too.
Start with the max.
I know we're about an hour and a half into the afternoon docket. It'd be good to take a 10-minute break.
It's fine. I have five inmates and the rest are waivers.
That would help me because I have to draft one and maybe two agreements.
Okay. Ms. Farkas, are you?
She's here for moral support.
Are you done already?
Yes, Your Honor, I am. But I learned by watching. So.
We can always learn.
All rise, please. Court is in a 10-minute recess.